everyone. I hope you have a good day so far. It's a beautiful sunny day here in Philadelphia. Again, good evening. My name is Honey. Welcome to World Financial Group Zoom session. Again, my name is Honey White and I will be your MC today. My background is nonprofit and government. I live with a husband and three kids in Philadelphia, Pennsylvania. Our topic today is create your lasting legacy. So you might remember Martin Luther King, Michael Jackson, Kobe Bryant, and Black Panther, Wakanda Forever, Chadwick Boseman. We all know these famous people, right? And do you know what is these famous people have in common? Yup, they all pass away, right? They all died. But what is really significant with our event this evening was because they made the news after they passed because of their estate planning situation, right? They not only famous and billionaire, but somehow their estate planning kind of a mess, right? They make mistakes somehow. So we want to avoid that. How are we going to avoid that? We're going to learn about will, trust, and of course, preserving your legacy. So before we start it today, I want to introduce you to our first presenter. Her name is Attorney Lorna Garcia. Attorney Lorna Garcia is one of the managing attorney for Intervivos Law. She's received Juris Doctor degree from Golden Gate University School of Law in 2005, where she was admitted as a Dean Scholar. Prior to obtaining her law degree, Lorna graduated magna cum laude, receiving dual undergraduate degree with triple concentration in management, economics, and finance from Notre Dame University. Lorna is a certified legal specialist with California State Bar. Lorna, the floor is yours.
Thank you, Hani. Hi, everyone that's here tonight. Thank you for joining us. I'm hoping to share some really important information with you that you don't already know, or if you do know it, strengthen that information so that you can remember how important it really is. Okay, so let me share my screen. Everyone see my screen okay?
Yes.
Okay, perfect.
Yep.
So as Hani mentioned, my name is Lorna Garcia. I'm one of the managing attorneys for Intervivos. And Intervivos is the law firm that Legacy Shield Professional Network utilizes in order to create custom estate plans. So as Hani mentioned, I am based out of California, but we do have state attorneys in all 50 states, okay? So all of you that are not in California, those of you that are in Philadelphia, in Florida, all of those fun cities and states, we will be able to help you, okay? And for those of you that are agents on the call, even if you're only licensed in a particular state, you still are able to sell this product or provide this product to your clients in any of the 50 states. Okay, so that's great information for you to have. So let's start with who needs an estate plan. Okay, everybody on this call needs an estate plan. You need one, everyone you know needs one. Now, depending upon each person is going to be how complex that estate plan is, but everybody needs one. And the purpose of it is so that you can say what happens to yourself, your loved ones, and your assets, right? We work very, very hard all of our lives to make sure that we have nice things, that we have a beautiful home, that we provide for our children. Okay, we want to make sure that it does pass to them and all these taxes and legal fees aren't taken out of there if we can avoid it. Okay, we can tell each other, you can tell your husband, you can tell your friends, you can tell your family, you can tell me exactly what it is you want over and over, but until we put that down on paper, at that point, it's just a wish. Okay, the judge doesn't have to take anything into consideration unless it's properly put down on paper. So Honey mentioned a few of these stars earlier. Now, not to have an estate plan is actually pretty common. Okay, more than half of the country does not have an estate plan in place. Not for lack of money, obviously, because all of these people didn't have one, but a more lack of knowledge. Okay, so you guys just being here tonight, getting this knowledge is already one step ahead of more than half the country. All right, so believe it or not, all of these people on this page right now died without a valid estate plan. Okay, it's hard to believe, actually. When I saw it, I was kind of perplexed. Why wouldn't they have one? So earlier last year, we all know the great legend Kobe Bryant passed away, like Connie mentioned. Okay, so he did have a valid estate plan. The only thing wrong with his was that his youngest child hadn't been on there yet because she was just born 6 months prior. But it was an easy fix. Okay, so when Kobe Bryant passed, not only did he leave his legacy of being such an amazing basketball player, he also opened the floodgates in regards to the estate planning world as well as the insurance world. I believe one of his, if not the largest, but his insurance policy was the largest, if not the one of the largest, if not the largest insurance policies cashed through. I believe it's under the America group, right, honey?
Yes.
So everyone said, hey, we need an insurance policy. Kobe has one. We should get one too, right? And same thing for the will and the trust. Everyone said, hey, Kobe got one. He was a smart man. Well, what is this thing? We should get one. Okay, so that opened everyone's minds, which is a great thing. But obviously, our work's not done because what Honey mentioned earlier, Chad Boseman passed a few months later, and that was all over the news. He had nothing in place. He didn't even have a will. He didn't have a will in place. His plan, in order to leave everything to a certain person, was to marry her. He got married right on his deathbed, I believe, right? So that she could inherit all of his stuff. And she probably will get it. But guess what? They still have to go through that probate process. So more than likely, she doesn't have it yet. Okay, so it's a lot of heartache, a lot of money to go through that probate court process. So let's go through what happens if you don't have an estate plan. Most people don't have one, remember. So this is what's going to happen if they continue that way. The courts are going to decide who gets their assets or who gets your assets, who's the guardian of your children, and who's a personal representative of your estate. That means that person's going to come in, take an inventory of all of your assets, and distribute them however the judge wants them to. It may not even be someone that you like, but unless we indicate who our assets are going to go to, the judge is going to decide for us. Okay? Now, the courts are also going to decide how and when your assets are distributed. Now, why is that important? Why should you care about how and when it's distributed? You're passed away anyway, right? Well, it is important because for those of you maybe that have young beneficiaries, right, or young children, and you have a multi-million-dollar life insurance policy, or you have a lot of properties, rental properties, you don't necessarily want your kids inheriting that money right off the bat, right? And sometimes the judge will just order the money to be distributed to the guardians. If you don't know who that guardian is, you're just going to have to hope and pray that once you're gone, that guardian will spend that money correctly for your child. So we don't want to hope and, we can hope and pray, but it'd be better off if you put that down on paper and so you know exactly what's going to happen to that money if something were to happen to you, right? And what's going to happen to our children. Okay, this is a big one. Depending on the state, this is going to change a little bit, but for the most part, it's around 4%. When we go through the probate court process, the courts are automatically going to deduct 4% of the value of your estate in attorney fees. Okay, the probate court process is not an easy process. You're going to want an attorney to go through it. And when you go through that, the states usually automatically have a set amount that they're going to get paid, and that gets paid from your estate. Okay, so why is that important? 4% doesn't sound like that much, right? Okay, well, let's take a $500,000 house. This is the house alone. Remember, this is going to be calculated on your entire estate. Okay, life insurance, bank accounts, everything. So just on a $500,000 house, 4% is already $20,000, you guys. $20,000 that your kids are going to have to pay to attorneys so they can keep the property that you left for them. That doesn't sound right, right? There's no reason that they should have to pay attorney fees if we can avoid it. Okay, and we can, and this is how. I'm going to show you how. In addition to that, the government can tax your estate up to 40% of the total value of your estate. Okay. 40%, that's a lot of money, right? Yep. Well, in reality, right now, most of us are not going to have to pay 40%, okay, because the exemption is so high. The only reason we'll have to pay 40% in taxes if we have over $11.58 million in assets. I don't have $11.58 million in assets. You might, I don't. Most people don't. Okay, so most people are not going to have to pay that 40%, but that's going to change. At the end of the year, that exemption, we don't have the exact amount, but it's being rumored to be about I heard today, 3.5 million. So that means anybody that has over $3.5 million in assets, which is not going to be hard to hit now, 3.5, you have a home, couple rental properties, an insurance policy, you're going to hit that 3.5 pretty easily. Okay, then you'll hit the tax bracket. 40%, right? Nope. That's going to change too. At the end of the year, it's being rumored that tax percentage is going to increase from 40% to 77%. Yes. So 77% plus those attorney fees, you guys, that's almost 80% of the value of your estate if we go through probate. So if I haven't convinced you already that we don't want to go through probate, even in an uncontested matter, the process is going to take at least 6 to 9 months. Okay, what does that mean? That means if we have to go through the probate court system, you're going to lose all that money, or you may get taxed, all of that fun stuff. You don't decide who's going to get your stuff. It's still going to take 6 to 9 months. And that's in an uncontested matter. So that's saying, let's say I only have one child. Nobody else is going to get my stuff except that one child, right? It's still going to take 6 to 8 months. And so if my child is living in my house and doesn't have access to my bank account to pay for this house, guess what happens? If my house doesn't get paid for 8 months, the bank is going to default. They're going to take it away. Okay, they don't care if you're in probate. They just care about the bills being paid. So we want to make sure that everything passes seamlessly. Okay, so we don't want to go through that probate process. And I'll show you how in a second. Now, how do we do that? Estate plan. We need a valid estate plan. And how do you create an estate plan? Well, like I said earlier, it's going to depend on each person, right? But typically, we're going to create these first 5 documents. The will and the trust, and I'll go through the difference of those. The durable power of attorney, advance health directive, and the HIPAA release. Okay? Those of you that have businesses or know someone that owns a business, the number one killer for businesses is that there's no plan as to how that business is going to continue if something were to happen to the owner. Okay, so we want to make sure that's taken care of for businesses. Special needs. If any of you have children or beneficiaries that are receiving government benefits, you know that if they receive assets, that can be counted as income and they'll lose those benefits. Those benefits are really important. We want to make sure they can keep them, so that you'll need a special needs trust. And that's a whole nother topic, but I just wanted to touch on that because we specialize on those things. But typically it's those first 5 documents. Let me go through the 3 through 5. So power of attorney, health directive, and HIPAA release. Those come into play while we're still alive. Okay? Very important. If not more important than the will and trust, or if not as important, I want to say it's more important. Okay, and I'll tell you why. But the power of attorney comes into play while we're still alive. We usually don't go from alive to dead in 24 hours. Okay, we get old, we start to age, and our health declines, right? Sometimes when our health is declining, we become incapacitated, meaning we can't make our own decisions financially or our own medical decisions. In that event, the power of attorney is going to allow you to designate who is going to make those decisions for me. Who's going to make those decisions for you? Okay. Advanced Medical Health Directive. That is basically when you're in a position where you're in an incurable, irreversible state. So pretty much when you're on life support and you're not likely to come back, you decide, yes, prolong my life on those machines, or no, don't. Okay. You're not preventing your death, but you're just taking that decision away from your loved ones. HIPAA release is going to allow whoever you list on there to be able to talk to your doctors if you can't give consent. The reason I say that the power of attorney is not, if not as important, more important than the will and trust, is because if you were to do nothing today except the power of attorney, and you were to become incapacitated tomorrow, your agent could still create a will and a trust for you. Make sense? If you didn't have that power of attorney, nobody would be able to do it for you. Let's say something were to happen to you. Worst case scenario, something were to happen to you and there's no one to make those decisions for you. Your friends and family could go to the probate court and petition for what's called a conservatorship, right? So they can make those decisions for you. I can tell you off the bat, my firm charges about $5,000 to $8,000 to do a conservatorship, whereas you could have gotten it done with this one piece of paper. Okay, so very, very important to get this done while you're still able and ready to do it. Okay. Now, wills and trusts. What is the difference between the two? Okay. They both do the same thing. They both say how your assets are going to get distributed, how your debts are going to be paid, how those expenses are going to be paid. They both designate a personal representative, that person that's going to come in, make sure they take an inventory of what you have and distribute them. In the will, it's called the executor. In the trust, it's called the trustee. Okay, I'm sure you've heard all of these words before, but this is how they all play together. In the will is where you designate guardians for your minor incapacitated children. Okay, and both documents you're going to designate your beneficiaries. Now, what's wrong with the will by itself? Okay, the will by itself, a lot of people have wills. Okay, a lot of people have wills and they say, oh, I'm set, I have a will. What they don't know is that the will by itself still has to go through that dreaded probate process, right? We don't want to go through probate. There's one instance when I say go through probate. It's when your debts outweigh your assets and you have tons of debt, then go to probate. But if not, there's no reason you should go through probate, okay? Now, the way to get around probate is the trust. The most common type of trust is the revocable living trust, and that's the one I'll talk about today. There's many different types, but the revocable living trust is the most common because it's very flexible. Okay, a lot of people like it because they're not set in their ways. They can change it at whatever time they want, so long as you are not incapacitated. Okay, your mind's all there. You can change it however you want. The kids are acting up, take them out. You can do whatever you want. Now, with the trust, you're going to avoid probate proceedings and it's an immediate transfer. Okay. And within the trust is also where you can structure, okay, my kids can get 10% when they hit 18, 15% when they hit 21, whatever you want. You can customize it however you want. In addition to that, you can even say something like, they can't have the money at all. Okay, I don't want them touching the money, but they can use it to buy a home, they can use it to start a business, anything like that. Okay. Now, a lot of clients ask, well, just give me the trust. I don't need the will. I don't need both. Well, you do need both, and this is why. There's two main reasons. Number one is if you have young children, you cannot designate the guardians of your children in the trust. That has to be done through the will. Okay. The second reason is, let's say we create your trust today. We put everything you own in there and you're good to go. But next week, let's say Honey buys a new rental property, right? And it's doing so well that she forgets to call me and say, hey, Lorna, I bought a new rental property, okay? And then she passes away before we put in the trust. So what's gonna happen to that property? It's not in the trust. Does it have to go, who's gonna decide where it goes? Well, there's going to be some language in the will that says even though any residuals that Hani didn't put into the trust, it's still her wish that it be distributed per the trust. Okay, so it's almost a catch-all. It circles everything back into the trust. Make sense? Okay. So a little bit about what makes us different. There's a lot of you have a lot of options, right? Estate planning and probate work is our primary practice area. Like I showed you earlier, the laws are changing and they're going to keep changing in the next couple years or so. So you want to make sure that whomever you use is very well versed in the laws and how they're changing, because we want to make sure we use them to the best of our ability, right? We want to avoid taxes. We want to be able to make sure that our children or our beneficiaries are not going to suffer, or they're not going to have to pay any extra fees that they didn't have to. We have offices nationwide, and so we're able to represent families nationwide. So if you move cross state lines, you have properties in different states or clients in different states, we can continue to help you. Okay. With a custom plan, there's at least 2 attorneys always heavily involved in every step of the planning process. Now, for high net worth individuals, we will work in conjunction with tax experts to make sure that your estate tax liability is as low as it can be. We don't want to hit that 40%, and then later in the year, we don't want to hit that 77%. Okay, we want to preserve as much as we can. We also offer proper funding of your trust. Okay, so this is very important. I always say, if you haven't written down anything tonight, this is the one I think you should write down. There's always 3 parts to a trust for it to be valid, and you have to have all 3. Number 1 is it has to have proper language. No problem. You use an attorney, it'll be correct. It should be correct, right? It'll be correct. Number 2, sign it correctly and notarize it correctly. Easy enough, right? You'll have the attorney, you'll have the notary, it'll be signed correctly. The 3rd part is where a lot of trusts fail. This is why Michael Jackson's trust failed, okay? In order for the trust to be valid, those assets have to be transferred to the trust, meaning they have to be funded, okay? Our largest assets are usually real estate properties, right? That's going to include having to draft a new grant deed, signing it, notarizing it, and then recording it with the county. Okay, a lot of people don't take that extra step. And unfortunately, that's going to invalidate your trust as to that asset. Okay, so we provide funding of your real estate properties, and we give you instructions as to how to fund the rest of it, the bank accounts, the cars, all of that stuff. We've done a lot of market research, and so our fees are lower than most with the same caliber, and we're able to offer flexible payment options, okay, if you can't afford that lump sum payment. Okay. Again, my name again is Lorna Garcia. We're part of Intervivos, the Legacy Shield Planning Network. And for those of you that would like a free consult, we do offer complimentary consults. In order to schedule one, I recommend contacting whoever invited you today, and so that they can set up a complimentary consultation with our office. Thank you so much.
Thank you, Lorna. Such a great presentation. I personally learned more and more, right? Even though we did couple training before on estate planning, and this is not the first time I'm hearing from you. This is actually my 3rd or 2nd time. But of course, it's not an easy topics, right? And like you said, 50% or more than half of our population do not even have estate planning, or even do not even understand, right? I think a lot of people don't even have idea what estate planning is, right? So hold your question. I already see question on the chat, but we're not going to do the question until we finish with the second presenter. So the second presenter is my personal mentor. She is the senior broker of our office, the World Financial Group in South Philadelphia. Chenping Wu. Her background is psychology and neuroscience from Temple University. She have 2 beautiful kids and a wonderful husband that cook very delicious food. I personally adoring her. The reason is because she definitely the person that changed my not only my financial life but also the future of my kids' life. So, Chen Pingwu, the floor is yours.
Thank you, Hani, for the wonderful introduction, and many thanks to Lorna. This is actually my second time meeting up with Lorna, and thank you very much for the wonderful information. Because when I first wanted to learn about estate planning, Lorna was the one who actually gave me that whole breakdown, and I still remember it took me almost like 1 month to finally grasp the entire will and trust because it was so new. And I'm glad that during this COVID 19, I was able to take some time and to learn about it just because, will and trust was so foreign to me. I've always thought it was more for someone who is more wealthier, have more money. That's when someone needs to have some kind of will and trust planning done. And I also thought, hey, if all the siblings are fine and we don't fight after assets, then you know the assets and properties will automatically go through whoever, whatever the case is. It happens to be like our family. My mom and dad has 4 daughters and 1 son, and being Fujianese Chinese, they're very particular. I think all Fujianese are like that. They want it for their son, and we all knew and we all understood that part, right? But then until I start learning about will and trust, I didn't know that if you have no if you had no estate planning, technically I could get a piece of the pie of what my parents have. Technically, all my siblings would have equal share, and we would have to go through probate process, meaning that we could spend that 2 to 5 years just waiting for someone to look at our case and then charge us a percentage of all my parents' assets just so they could equally share, their assets to us. But we all know as sisters, we all know that that's not what my parents wanted. My parents wanted for my brother, and we're all okay with that. We want my parents to be happy with that, right? So now we understand the importance of will and trust, of course. So, my parents are actually working on their planning. But more importantly, it was more that I found out and I realized it was very important for me, for my family to learn because my family is we're still a young family. We're building our wealth and asset. And, Lorna, you just threw a bombshell just now about that estate planning tax going from 40% to possibly 77%. And that bombshell that, 11 million estate planning exemption all the way down to 3.5 million, that is horrifying because I'm already worth more than that. And now this is where I know we have to have another conversation about a little bit more sophisticated trust planning now because we have to do proper or else we're building wealth for the government. We all work so hard. I know many of us did not intend to, build that wealth for government, right? So, just from my personal experience, I'm really glad that I was able to gain this information and knowledge. And, literally during this COVID 19, I was able to set up my will and trust. It felt so amazing. I love the name of I love the fact that we get to name our trust as well. So we named it Champing and Michael's Legacy. Actually, we call it Champing and Michael's Family Legacy. That was our trust name. And that just felt so empowering because I work hard and I want to make sure I get to designate my wealth and my assets to the people I love and care for. And I love the fact that I'm able, through a trust, I'm able to do more than one layer, like 3 layers, of different allocations, right? And I really do appreciate Lorna for teaching me something about the pot planning, all of that. So I just want to share with you guys a little bit of my process. And I do have to say, it's not a 1 day thing. It's not a 2 day thing. For a normal trust planning, it could take at least a month because, first, say example, Lorna needs to meet with you, get to know your situation, and then she would have to share with you what are some possible suggestions, and then you get to finalize what is it that makes sense for you as well. So for me, I definitely go through that process, and I still remember literally last time I had a meeting with Glenn I think it's Lorna's boss, right? I met up with Glenn, and he started asking me all these questions. I'm like, my husband and I, we never thought about, and we never think that, it's a lot of planning, definitely a lot of planning. But the moment I had it done, it was definitely like, whew, I felt what a relief, because I knew that, my family's taken care of. I knew that, what, we're maximizing our wealth. We're not going to be working for the IRS. We're not going to be working for the government, right? We're going to be working hard and transferring our wealth to our family in a most effective way. So that felt really good. Now that Lorna just provided me some updated information, we got a little bit work to do. Well, we're waiting for the law to, change. And just as Lorna sharing with me, my mind is like, okay, what is it that I could do, and how can I, properly have a little bit, create a little bit more asset properly with the other. So where we're talking about is actually irrevocable trust planning now, because of the estate tax is going so much higher. So I'm really excited, and I'm really grateful that we have access to such information, and because of that, we're able to you know to get all that, to have that relief, right? So I just want to share that testimony with you guys, and many of you guys who want to have access to Lorna, or get that complimentary info session. Feel free to reach out to the person who have invited you, contacted you, because we can definitely schedule that appointment with you, with whether it's attorney Lorna, or with attorney Glenn. There are many attorneys, and one thing I love is that they are able to work with our schedule and across the nation, so they really know their stuff. It's a lot of information, but it's so good to be knowing this information ahead of time. Thank you, Honey, and also Lorna, for giving me the time to share. So I'm gonna give the mic back to you, Honey. You're muted,
Thank you
Honey.
so much, Chen Ping, for such a great sharing. And of course, we want to hear from you also a little bit, Chen Ping, about WFG, about World Financial Group. I guess because we hosting this presentation. So could you tell us maybe in a 1 or 2 minutes about our office?
Yes. So our office, World Financial Group, we're based in South Philadelphia. We've been around. I mean, I've been in the financial industry for almost 10 years now, and our office, we opened up our own branch in 2017. So we're really excited, and the network that we have with Intervivos and also Lorna's firm is that we are a networking firm, and one of the niche about us is that we're really all about educating, providing enough information so people are more educated and they will make better decisions. For me, that's how I make decisions. Maybe it's because of my research background, where I love, to have good resources and make the best decision, right? So likewise, the relationship with us and Lorna is that not only will Lorna will help us with estate planning, but here with World Financial Group, we will also find, the suitable plans, financial solutions to magnify your money. So that way, not only you're able to grow and magnify your money, and also being able to estate plan and also preserve your wealth for your next generation. So this is definitely a great combo. Sometimes I think the best way to have a good, proper financial planning is to be well-rounded, right? You don't want to just be a tax. Yesterday I was just hearing from a CPA in our firm who is very successful, owns a very successful CPA firm, and he's also a expert, in our company as well. And he says one of the biggest reasons why CPAs out there are so different from a World Financial Group associate with CPA is that we're all well rounded. We know about tax planning, and we know about for the future as well. Many CPAs, for example, they probably only talk about saving your taxes for this year or next 2 years, but they're not going to talk about lifetime, tax planning. And that's where financial planning comes in. So that is the relationship that we're having. And, many of you guys who have been online with us, you probably see that we're involving many experts together to, grow your wealth, our wealth. So this is definitely the time where we're working on providing more well-rounded information so we can cover our finances in many areas. So hopefully I give you guys enough information or some information about our company. But if you want to learn more about what we do, feel free to contact us with any of the person who have invited you, and then we can actually share a little bit more about what is it that you could benefit from our services.
Thank you so much, Chenping, for all the information. And Lorna, absolutely such a great message this evening. And for those of you that have a question, feel free to put it on the chat. So we're going to go with the first question from Miss Lamaya, right? Our good friend here. So I just want to make sure that I understand your question. And if not, feel free to unmute yourself and ask the question. But Maya asks Lorna, even if the will has the catch-all language in it, so is it meaning that like you still need to do trust even though all the will already have all the language? Is that what you mean, Maya?
Thank you, honey. And thank you, Lorna, for this information. It was really good. It was more so when you were speaking about the problem that is so common with the trust, and you said the third part is when the assets are not transferred. And so but I know earlier you had said when it comes to the will, that if the will have the language in it that covers all of assets not been included, then it could be covered. So can you explain that a little more? You're
Lorna,
muted.
you need to be unmute.
Sorry, I do that all the time. So, very good question. So that catch-all phrase in the will, that is going to allow it to be distributed per the trust. However, if it's not funded in the trust, it still has to go through probate. Okay? So what it does, what that catch-all in the will does is it still distributes it per the trust, but it still has to go through the probate process. So it's so important that it has to be funded so that you can avoid probate. What the will is it's pretty much a script, I want to say, for the judge to go by. Okay? Because if you go to probate, you either have a will or you don't, right? And the will, if you don't, then the judge is going to decide. But if you have a will, then the judge will have something to go off of. And if you have language in there that says, even though, honey didn't put this, it should still be distributed those exactly the way it says in the trust, then that's how it'll go. But it still has to be funded if we want to avoid that probate process.
Okay, so with trust, then I'm assuming for your assets you have to pay, then you paying an amount for your assets to be covered in a trust. Is that what you're saying?
No, it just has to be transferred. So
Okay.
for a house, we just have to record it with the county. For banks, you just have to let your bank know that you have a trust so that they can pretty much title it for the
I see.
trust.
Okay, so if that item is not registered, then obviously you cannot, then your family or whatever can't have that item if it wasn't registered with the trust, is what you mean.
Exactly.
So I'd like to add that, I
Okay,
love the
got it.
fact
Thank
that,
you.
well, I like to add that one thing I love. Do you remember earlier I had shared about that? I get to name the name of my trust, Chemping and Michael Family Legacy. So when you go to a bank and then they ask you who are your beneficiary, it's going to be Chemping and Michael's Family Legacy, right? Or our IRAs, our 401ks, our life insurance, whatever. Whenever they ask who are your beneficiaries, we get to name that the name of our trust. And then in the trust, it has all these instructions of how we want the money to be distributed. It's so funny. In my trust, I talks about, I have three other sisters, and I see, each one of them have different strengths, and I'm able to allocate and designate different roles just for them to help, take care of my finances for my kids, because my kids are, very young. One is only 3 and the other one is only 19 months. So you can get fun with something flexible like a trust. I just want to add that in there.
Okay, thank you.
Thank you, Lamaya, for the question, and thank you, Lorna and Chenping, for the clarification. So Helen has a question about the consultation fee. Yes, Helen, make sure you get in touch with the person that invited you through our network. You're going to get free 30 minutes consultation. And let me tell you, this 30 minutes is really, really worth couple $1,000. I'm just so thankful that we are in our network, right? So please, if you get invited by someone, please thank the person that invited you and tell him or her, I would love to get this free 30 minutes consultation. And we could pair you with great lawyer. If Lorna is not available because she's only one person, right? There is another lawyer that really as good as Lorna. But we love Lorna very much, right? So next question. All right. This is from Amber. Hi, Amber. She's also in San Francisco. She is in California like you, Lorna. So Amber have a question. Is the tax you mentioned as government tax including inheritance tax benchmark 40% to possibly 70%?
So, Ambar, that's going to depend. I believe inheritance tax depends on each state. Now, California at this point does not have an inheritance tax. I believe, off the top of my head, I know Pennsylvania has it, New Jersey, Kentucky, and Nebraska. There's two other states, I believe, but there's not many. But it's going to depend on the state as far as inheritance tax.
So I guess you need to clarify a little bit about the one that you mentioned going to jump up to 70%.
The estate tax. So pretty much what's going to happen is that the government is going to look at your assets as a whole. They're going to just total it all together. Now remember, insurance, life insurance, although it's income tax free, it is not estate tax free. So if you have a large insurance policy, that's going to be counted towards the dollars of your estate. And so if you're currently, if all of your assets, so long as they're under 11.58 million, you won't get hit with the 40% taxes. Okay. Now, what the proposed change is they're going to bring that 11.58 million down to 3.5. Okay. So what that means is anyone with assets over or their estates over 3.5 million is going to get hit with the taxes, right? And it's not 40% anymore. That's going to change. It's going to get hit. It's going to increase to 77%. So you can imagine how that's going to change a lot of estate planning. Chen Ping, she knows she's probably going to have to change. A lot of people are going to have to change because 3.5 million sounds like a lot, but if you own a home and you have life insurance policy, you're already close. Yeah. So that's pretty much the way of the land right now. It hasn't changed yet, but it's rumored that it is going to change at the end of the year.
Lorna, just on myself, I have more than 4.5 million. So
yeah,
I've been very careful with that number because I thought it's gonna go back to 5.5. Then I'm like, okay, I could possibly hold on that irrevocable trust. But anyways, we'll talk more because as the law is changing, we have to adjust planning. Anyways, it's all good. We move with the trust. Just hope that we don't die during this period.
And it does sound scary, but we have a lot of different ways to be able to move the assets, and so that you'll still have control, but it won't be counted as an asset as part of your estate. So
this is such a great information. Amber, I think we discussed this a little bit when the first time we met about the move to 3.5 million. And now it's getting real, right? It's getting really real that you say it's going to be at the end of the year, and the end of the year could come just like a blink, right? And let me ask you another clarifying question, Lorna. This is federal changes, right?
Yes.
Meaning this is entire 50 states.
Yes.
Okay.
It's the federal estate tax, yeah.
Federal estate tax. So doesn't matter you are in Pennsylvania, whether you are in California, you will get hit by this 77% if they actually go to.
Misery loves company.
Like a lot of people are going to sweat like bullets now. All right, next question from Lely. Do we have to put our asset in foreign country if we have one such as the asset we earn before we marry? Do you understand the question?
So is it, so if you had an asset before you were married in a foreign country, do you need to put it in the trust? Is that?
Lely, do you want to unmute yourself to make sure we answer? Yes, Lely, say
Yes.
yes.
Okay.
Okay.
So it's really going to depend on the country. What I usually do is it doesn't hurt to list it. I always just list it because it doesn't hurt you to list it. But what I do like to do is reach out to one of our partner attorneys in that country to determine if maybe an addendum is needed or if you just need a brand new trust in that country.
Okay. Great answering. Thank you for clarification. I'm sorry, somebody say something?
No, I say thank you.
Oh, I'm sorry. Okay,
Welcome.
good. I'm glad Lorna answered your question. So, Lorna, I have someone texting me a question. Can I ask you this?
Sure.
So she say that sounds like trust that you explain. It's like a giving grant to your beneficiary. Um, because grant is actually like it's like just giving money, right? Instead of like basically her question is it correct that trust is almost similar like giving grant to your beneficiary?
I mean, sort of, yeah, you're leaving them money. What the trust is going to do for you, though, is it's almost like I describe it like a wagon, right? So you're gonna leave, assuming you're gonna leave your assets to your children anyway, right? Or your nieces and nephews, whoever it may be. Now, usually, if you don't have anything, we have to go to court, and the judge has to say, okay, so and so, child one, two, and three, they now own it because their dad's no longer here. Okay, that's probate. Now, how I describe a trust is it's almost like a wagon. So you're gonna put all the stuff in the wagon, all your assets, but you're still holding the handle, so you still have it. But when you pass away, it's almost like you're just passing it over. You're just going to roll it over to your son or your daughter, and they'll now have the wagon. And you don't have to go through that court process because the wagon was holding all of those assets. Does that make sense? So that's pretty much what it is. And it's almost like a grant. I mean, you're leaving them things, but the trust is nice because you can structure how you're going to leave it for them, whether it be a certain dollar amount every month or whether it be for a specific purpose, right? Or until they're a certain age. And so that's what I would say the trust really is for.
Okay, great. And there is another follow-up question, which is, I think it's pretty difficult. Let me try to translate this, okay? So, in my country, they use this type of grant to distribute properties to the kids to avoid tax, which could be pretty expensive.
So,
It, I don't quite understand the question. You want to say something? I'm sorry.
Yeah, I think so. So a trust sort of is like that. There's many different trusts, and it's going to depend on each state. Okay, so as far as how the taxes are. So here in California, there's a tax law that just came down. It's called Prop 19. Okay, so before Prop 19, a parent could transfer property to their kids and the property tax wouldn't get reassessed. So the property tax would just stay the same. Well, Prop 19 is changing that. It's saying, nope, it's going to get reassessed is when it changes hands to your children. Okay. And that's a huge deal here. And so that's why everybody's scrambling because it has to be done by February 15th. Now there is some exceptions to that, but it really is going to depend on each state. So that's very important as far as Yes, a trust is going to transfer stuff to your children, but you may need a different type of trust. Like here in California, you need a different type of trust to make sure that your properties are not going to get reassessed and your kids don't get hit with exponential property taxes. You know, so.
So when you say reassess, meaning that once you pass away and you transfer the property to the kid's name, that they going to have the tax due based on the now assessment. What?
Yeah, so if your parents bought that house 50 years ago, it's going to be, especially, I don't know about your guys's, I mean, property always, grows.
Yeah.
And so, but if you're in an area where it just exploded, your kids are kind of screwed, right? So we want to make sure that it's set up so that there's, hopefully, if we can, make every effort to make sure that it's not reassessed so that they can just continue paying the same taxes, if not a little more, not not the entire amount.
Okay. Wow, good to know. And you do not, that's happened in California, and you don't see that happen in other states so far?
I'm sure it has, but I know what's pressing right now is in California. The deadline is February 15th, and so you can imagine everyone calling. But yeah, it can very well happen because that's the way to get taxes in, right? The government needs more money. The way to get it in is taxes.
Yep. And California losing a lot of big company. Everybody moves to Texas.
Yeah.
So we have another question from Lamaya. So what happened if all family is a written paper signed, maybe even notarized, listing their loved one wishes after they die? That's not legal binding. Oh, okay. I understand. Do you understand the question?
Yeah.
Yeah. Okay. Good.
So that's a good question. It's really going to depend on each state. Each state is going to have their own laws as to what is legally binding for a will or what is legally binding for a trust. And there's also specific language, right? Each state has specific language that has to be included in all of these documents for it to be binding. And so I know in some states, a will only be binding if it's handwritten, if the whole thing is handwritten. And so each state has different, so each state has different laws or rules as to what's going to be binding.
Okay, great. Do we have any more question? I think we're going to end that one in a very, very good 1 hour here, because we want to keep it an hour. We want to keep it really short. Any other question or anything to add, Chenping or Lorna, before we end it? We at 7:55 now.
I have a
Philadelphia
question.
time.
I have a question, Lorna. So for me, I just, can you share with us if anyone were to go to probate process, what is the average timeline that, assuming the probate process will go through, and what is the cost? Because I just hope that through this event, we're creating enough awareness for people to start thinking more about will and trust, because if they don't, they could be missing a lot or losing a lot of money just because they didn't do some paperwork like a trust, right? So what is the average timeline, and what is the expected cost if someone were to go through probate process?
Okay. So to put it in perspective for you, the cost of a probate, just the filing, is going to be I can give you California's because I know it very so well. The filing in California is $435 just for the filing. In addition to that, it's going to be a sliding scale of 4% of the value of your estate paid in attorney and legal fees. Okay, so like I said earlier, a $500,000 house, that's easily $20,000 at least. Okay, now, so that's 20,000 plus your 435. That's I would say well over close to 30,000. And then the time it takes is about 6 to 9 months uncontested. So it could take years. I want to say Amy Winehouse's took 9 years. Okay, wow. So it could take a long time. Now, an estate plan, that'll take about, I want to say 6 to 8 weeks at the most. Assuming we're really busy right now, 6 to 8 weeks. The cost of it is going to start at $2,000. So, it's a fraction of what your loved ones are going to have to pay later. Okay, so
Yes, and Lorna, I think people also need to understand that $20,000 plus $400 need to be paid in advance. They cannot. Some people say like, that's not big money because we have a $500,000 assets. We could just sell it and pay that 20,000 after we sell it, right? You need to kind of like elaborate that a little bit.
yeah, so it's a lump sum. You can't pay it in payments. It's going to be taken out of, and if you don't have the money to pay, it'll be taken out of the estate. So if there's a home, the home will have to be liquidated, and then the money be taken from there before you receive it.
So I also want to add this part because I'm actually going through an example with a family where they are going through that probate process, and it's a pretty lengthy, I'm walking with them through the entire process. They're just getting started. And as I'm hearing, banks is frozen. They cannot, the spouse cannot touch because of the way it was set up. They're not even legally married, which a lot of Asians do that. They don't always have paper marriage, right? So because of that, they couldn't have access to the assets. Accounts are frozen. And now, say example, the person who passed away has 3 properties and nothing could be done about it. Taxes are due, they have to pay, but the 3 properties are pretty much waiting for a probate decision. And so far at this moment, it sounds like it's uncontested, and already 5 months went through. Already 5 months passed and we're still waiting. Hopefully if it is uncontested, then we're talking about that 9 months period, but we don't know, right? We don't know. What if, based on what I'm hearing and what I'm seeing, it seems like it's uncontested. But what if someone out of the blue, like a brother or a sister, comes out and said, you know what, I want to contest. I want to go after this property. Now, all of a sudden, it becomes a very long and lengthy process, right? So, but fingers crossed for the family. But I just want to let people know, the difference between having control and losing control, right? Being able to set up a trust and a will plan ahead of time, definitely have control and ownership of what you want to do in the future. Versus if you are not having it just because you didn't know about this information, well, you're going to lose control. And is that something that you want for your family? That is something I really encourage and challenge you guys to think about, because that's the entire goal of what we have, why we have this event, because we want to create more awareness for people to start learning and understanding how to do proper financial planning for their better future.
Thank you, Chenping, and especially during the COVID-19, right? Even in my own network, we already have people pass away, and it's not discriminate, right? Some people pass away, they're on their 60 or 70, but just 2 weeks ago, we have in my community someone that 42 years old. He is healthy. Like nobody see this coming, right? And he just died, like after get COVID for less than a week. So it just really a big loss. So Lorna, any closing statement?
No, I hope that I was able to educate you all tonight, far more than you already knew. And so, and I hope you realize how important it is to get an estate plan. And so I would take advantage of the complimentary consultation if you already haven't done so, and so that we can help you through this process.
Thank you, Lorna. How about you,
Thank
Chenping?
you.
Any closing statement?
That's I hope what we did, enough awareness for you, definitely. And earlier, Hani, you said about 42-year-old. The family I was talking about was only 35.
That's even worse,
Yeah,
right?
very young kids, very young kids. That's why when I heard that situation, and at that time I was thinking about estate planning, I hurried up and said, Glenn, send me the paperwork. Sometimes we need that, right? But I'm, anyways, I am glad that I have that relief and we have it done.
All right, Lorna, thank you so much for your time. We really
Thank you.
appreciated you in the middle of scrambling the deadline of February 15 for your state, but you still show up at our Zoom. We really,
No
really,
problem.
really appreciate it. And
Thank
guys,
you.
get in touch with the person that invited you, right? Take that 30 minutes consultation. You will be grateful. All right. Have a good night, everyone. Enjoy the rest of your evening and please stay healthy. All right. Thank you, guys.
Thank
Have a
you.
great night,
Bye.
everybody.
Have a great night.
Thank you. Good night.
Can we have the
Yeah, somebody saying something?
yeah, I just wonder because I came in late. You're already recording our
Linda, we're gonna have a Chinese version on the 31st at 6 p.m. Oh, I should have tell everybody that. Okay. Yes, we're gonna have another Chinese version in on the 31st. So it would be really good if you could hop on to the Chinese
31st.
event with us. Yeah, it's gonna be at, let me check what's time. We want to really create this awareness to people because it's very, very important.
We have Indonesian version tomorrow at 8:30 p.m.
Oh, wow. Look at you, honey. Okay, so we're having it on 31st, 6 p.m. to 7 p.m.
6 p.m. to 7 p.m. At the Eastern time?
Eastern time, yes. And make sure you're on time because, yeah, we're going to end on time.
Yeah, because and how we can give your question before.
Yep, we will. You can, so Linda, if you have questions ahead of time, you can always shoot it to me and I will prepare our attorneys to answer these questions.
Okay,
Yeah.
thank you.
Okay.
Helen,
thank you. It's good to see you. I just want to say bye to you. We all miss you, Helen.
Ty, we would like to see if you could reschedule with your pre